Under your interpretation of 94004, there would not be an exception for sexual assault or rape, correct?
I believe that is correct, unless it was necessary to save the life of the mother, or two doctors said it was.
There would not be an exception for incest, correct?
I believe that is correct, unless 94004 sub 5 applied.
There would not be an exception for the health of the mother, correct?
I believe that's correct, unless it's 94004 sub 5 applies.
There would not be an exception for a fetal abnormality, correct?
I think one of the elements for a violation of 94004 sub 1 is that it is a living unborn child, so I guess it would probably depend to the extent of the fetal abnormality. If it's a situation where in the death of the fetus, I don't think you could apply this statute.
That was Justice Jill Karofsky grilling Matthew Thome, attorney for Sheboygan County's Republican District's attorney, Joel Urmanski, who has approached the court to overturn a Dane County judge's 2023 ruling that annulled the 1849 ban against abortions. She eventually went on to comment, "This is the world gone mad." Hello and welcome to News Blitzer. Wisconsin Supreme Court's Monday review of the applicability of an 1849 law banning all pregnancies except for abortions that concern the mother's health bore all indications of heading for a win for the pro-abortionists. The 1849 law was overturned by the 1973 Roe v. Wade judgment, which lifted the ban on all abortions in the U.S. and guaranteed women the right to an abortion up until the point of fetal viability, which is about 24 weeks. The 1973 ruling, however, was again overturned by the U.S. Supreme Court in 2022. The issue came up again after the Dane County District Court passed orders in 2023 outlawing the 1849 law. The court's leaning towards upholding the lower court's ruling was even more evident with the following observation by another liberal justice, Rebecca Dowlett.
So in 1849, we're talking about a time when the only people that had rights were white men, correct? With property. White men who own property, sorry. Is that right?
I'll take your word for it, Justice
Okay,
Dowlett.
well, you can. And let's go past 1955. We have statute after statute that you are somehow asking us to just absolutely ignore in your interpretation. We have a statute that was 253-107 that talks about when an abortion can be performed, and that's after 20 weeks. We have a 24-hour waiting period statute. We have informed consent provisions. We have a ban of what they label to be partial birth abortion. We have a requirement about what a physician has to do in terms of admitting privileges. We have when a physician can provide a medical procedure, and on, and that's not even 940-15. So what about all those policy decisions? What about everything that's happened since 1849?
It is clear from these and other remarks and observations of the judges, along with cross-questions, that the court was not in favor of evoking the 1849 ban. But the real challenge that the courts are facing is not about upholding the lower court's ruling against the 1849 law. Considering the issues such as victims of rape, incest, and exploitation that were raised by the judges, drawing a balance in abortion law is the real challenge. This is because, while it is true abortions for victims of rape, incest, exploitation of the innocence of teen girls, and in cases of fetal abnormalities, is justified, it is also a fact that a free-for-all 1973 has also led to an explosion in abortions in the U.S. This is particularly borne out by the fact that after the 1973 ruling, abortions rose from 500,000 in 1973 to 1.6 million in 1990. That's a 300% rise. According to CDC, the number has now declined to a little over 1 million abortions in 2023, but it is still twice the number after the 1973 ruling. Surely, common sense says the massive hike in numbers of abortions in the period is correlated to the free-for-all of the 1973 ruling. Further, the issue is also multifaceted. According to a Pew study using data provided by CDC, 87% or the vast majority of women who had abortions in 2021 were unmarried in the District of Columbia and 46 other states, while the majority or 57% of women who had abortions were in their 20s and about 31% were in their 30s. Teens ages 13 to 19 accounted for 8% of those who had abortions, while women ages 40 to 44 accounted for about 4%. At the same time, over 73% of young adults in the 18 to 29 age group say abortion should be legal in all or most cases, compared with 62% of those 30 to 49 and 57% of those 50 and older. As a result, the courts cannot ignore the fact that it is largely unwed mothers who are aborting babies, that there is a reason for this trend. More often than not, especially among unwed girls and women, abortion is not a choice, but a compulsion heaped upon them by society. In a study titled Unwed Motherhood, Adoption Reunion, and Stigmatized Social Identities and published in the March 2019 issue of Western Michigan University's Journal of Sociology and Social Welfare, it was found that each respondent woman in the study spontaneously described in her interview at least one incident where a significant other, such as a parent, a sibling, or a friend, had either stated or implied she was sexually promiscuous. Interestingly, says the study, the women did not challenge such attributions because they viewed them as a byproduct of their own failure to maintain the normative standards of sexual purity expected by their generation. Social stigma and the associated mental trauma is a very real eventuality that unwed mothers have to face and is a major driving factor for abortions, and there is nothing that the courts can do about it. Likewise, the issue also intersects with the decline of sensible social mores over sexual relationships outside of wedlock, with the normalization of extramarital sex, and with the surge in online content fueling a sex explosion. 70% of adults in the 18 to 20 age group saying abortion should be allowed in all or most cases indicate deeper problems over sexual activity among young adults in the U.S. But issues of stigma and social mores are not something that the courts can address unless it comes under the gambit of law. The circumstances that drive women towards abortion are myriad, some unavoidable, others entirely avoidable. The issue primarily calls for deeper introspection by American society. It calls for an attitude change towards unwed mothers. It requires revisiting abandoned social mores concerning sex outside of wedlock, and above all, girls and women opting for abortions need to be understood as victims of folly and of the times and need to be provided a positive way out without opting for abortions. Meaningless abortions need to be curtailed, but being a personal issue, the law also needs to protect the rights of girls and women under the overall parameters and spirit of the Constitution, along with concern for the future of affected girls and women. Consequently, while there is no doubt that the court will eventually come to a ruling, even the best court ruling in this issue is only half the solution. The rest is up to society, its leadership, its influence structures, and its values. Any legal solution will only be a halfway house. The matter also needs to be insulated from politics. Both Democrats and Republicans rode the abortion issue for electoral benefit in the recently concluded U.S. elections, but in reality, what they have accomplished is to deepen the fissures in public opinion on the issue at a time when a middle line that is in interest of girls and women is required. Both parties need to respect the feelings of women who find themselves pregnant in difficult circumstances, and take the welfare of women forward, not backward. Thank you for watching this video, and if you have not already done so, do subscribe to this channel for cutting-edge news reports and news analysis. Thank you once again.